National Prosecuting Authority says it's ready to proceed with the trial against the former President Jacob Zuma, despite the resignation of his legal team. The firm Mabuza Attorneys resigned as his legal representatives today, less than a month before his corruption trial is set to begin. This will also effectively include the resignation of the advocate, the senior counsel, Muzisa Kekani, and the other counsel, Tabani Masuku. The corruption, fraud, money laundering and racketeering trial of the former president is due to begin on the 17th of May in the High Court in Pietermaritzburg. While the reasons for the withdrawal of the attorneys have not yet been made public, this may have an impact on the start of the hearings. At the same time, the Supreme Court of Appeal found last week that the state is not liable to pay for Zuma's legal fees.
We're now joined by the National Prosecuting Authority's Sipho Ngwema. Mr. Ngwema, good evening and thank you so much for your time. Firstly, have you been given reasons by Zuma's legal team for why they've pulled out of the case?
Good afternoon, Cathy and Steve. Thank you very much. What I can say is that indeed we did receive a note from Mabuza Attorneys. Of course, the content is for them to divulge. But emanating from the matter that they are on record for, which is the state versus Jacob Zuma, we are ready to proceed for that matter. It's starting on the 17th of May. We have consolidated our case, and we want the matter to start. We want justice to be done, and we don't foresee anything that should be a stumbling block towards that matter starting on the 17th of May.
So are you saying that the idea of Mr. Zuma having to get new legal representation on board won't have any kind of bearing on the start of this particular trial?
Look, the note was sent to court. If there are any other issues, developments that have to do with the starting of the case, the court would have to deal with that. But as the state, as the National Prosecuting Authority, we worry about matters that concern our case, our state of readiness, and our ability to start as soon as possible. If there are issues that emanate from the side of the defense team must worry about those things. On our side, we want to start. Of course, we know that a lot of people have been trying to insinuate that the delays were on our side. We want the matter to start as soon as possible. We are ready.
But of course, you also have to worry about it, because if the defense is not ready to start, then there will be no trial, at least until such a time as Mr. Zuma has found appropriate legal representation.
If those matters do arise, the court will have to deal with that. But for now, our concentration, given the fact that the last time we met, we agreed on a date for a trial to start in earnest and for that to proceed for about a month. And we are busy with those processes. So if the parties in the matter have got other things to deal with, they will raise that with the court, and the court will have to deal with those things. But from our side, I want to emphasize the state is ready to start with the matter against the accused, number one in the matter, which is former President Jacob Zuma.
So you've been given some of the reasons for why this has happened. Is there anything sinister at play here? And the reason I'm asking that is because already we have some people opining and saying, well, this is part of the strategy to delay the processes as long as possible, to avoid the start of the trial for as long as possible.
As I said, we received a note as a matter of courtesy. It was not addressed to us. It was addressed to the court, and it's up to the court and the authors of that note, which is the defense team and lawyers, to comment on the content of that letter. For us, our concentration right now is the case that we want to put before the two accused in the matter, and this is what we are concerned about. But if there are other issues in relating to the parties in the matter that they must worry about, it is for them to think about those issues and see how they deal with them.
What happens if this trial doesn't start on the 17th of May as initially expected?
Look, if anything, as I said, the court must decide what happens if there are arguments that would have to be raised in terms of any development that we don't anticipate now happening on the day that the court will be faced with the those facts, and they will have to decide. But from our side, we want the matter to start as soon as possible so that justice is done, and those who wish that they can be heard or have their day in court can have their day in court. And their day in court is on the 17th of May, and they will have it, and then they should take that opportunity with both hands.
The NPA's Sipho Ngwema there, as you heard, unequivocal in terms of the message from the prosecuting authority. Let me bring in legal analyst Benedict Phiri. Mr. Phiri, good evening to you too. Is it optimistic of the NPA to still believe that this trial will get away on the 17th of May, despite the fact that Mr. Zuma's legal team has about just a couple of weeks to try and find legal representation that will be able to carry him through this trial?
Good evening, Cathy. I think, yes, it is a little bit on the optimistic side to believe that we may have a trial commence on the 17th. You know, whatever lawyer comes on board to represent Mr. Zuma will have to absolutely get on board with the matter and understand the matter entirely. So as to, you know, give him a proper defense in the matter. And I suspect that the first thing he will do, or he or she will do, will be to apply for a postponement of the matter for that very reason, which I think a judge may be inclined to give to ensure that the matter is ventilated properly.
Of course, the NPA isn't really forthcoming in terms of that note that they were given for why the situation has happened. You, of course, are a practicing lawyer. You've seen, you know, scenarios like this from time to time. Perhaps some of the top 3 reasons that we see a split between legal teams and those that they're representing, especially at the 11th hour like this?
Yeah, you usually see attorneys withdraw, for instance, where fees are not paid or timelessly paid. Sometimes attorneys withdraw if the client has a totally different strategy in place and does not agree with the attorney on the way the matter should be handled. You know, sometimes, you know, attorneys withdraw because the client effectively has instructions that are contrary, for instance, to ethical rules or how the attorney thinks the matter should be run. So those are typically the scenarios that you find that attorneys withdraw rather than sort of clients say, we're terminating the mandate.
Generally, how long would Zuma's new legal team need to get appraised with all of the matters around this case before it can actually go to trial?
That's very hard to say, Cathy. You know, it all depends on really the amount of work and the amount of documentation and materials that they actually have to get through. You know, we don't have a sense for that, but it does seem like a fairly big and complicated matter, which would require quite some substantial time to get under. You know, their witnesses, their witness statements to check. And, you know, any attorney wouldn't necessarily take what they're seeing on paper and would want to make sure that they actually understand what's happening firsthand. But having said that, Mr. Zuma does have 10 days under the rules of court to then appoint an address effectively for where he'll accept service. And I anticipate that we'd get some kind of confirmation of who his new attorneys will be within the next 10 days.
So we'll know in 10 days who might be representing him next, but the legal team, when this matter is actually heard on the 17th of May, can they propose, let's say, 6 months for them to get appraised for this matter? Can they ask for a year? So all I'm trying to get a sense of is there a framework under which these things are generally done?
Yeah, they'll have to ask the court to give them a reasonable time, and they'll have to explain to the court what they consider reasonable in the circumstances. That's to the extent that the NPA doesn't agree for a postponement. So, you know, the framework and the timing will really be fashioned by the court given the complexity in the matter and the amount of time that would be required to get up to speed.
Do you think that it could be made public then, the reasons for the withdrawal of Mr. Zuma's legal team?
I I think it's unlikely that the reasons will be made public. The notice of withdrawal is public, and that suffices. And I think the reasons are then, explained as you've said, to those that are on a need-to-know basis. It may be that a judge may inquire as to the reasons, to the extent that he's not aware of them, or may want to probe them further. That might happen, but it's unlikely because the notice of withdrawal is on the record.
All right, let's leave it there for tonight. Benedict Phiri there with us.